I welcome you all back once again to our channel, and this is Advocate Frederick. This session is part 9 of our target to complete 50,000 multiple choice questions in law. These 50,000 questions will give you the confidence to crack any legal examination which is conducted in your state, be it the civil judge examination, judicial services examination, or any special legal officer examination which are conducted by various departments in India, or even the district judge exam. You would have the confidence to get 100% results in all these examinations. The motto for me to do this 50,000 multiple choice questions in 1000 parts free of cost is that there are many students who are not able to afford proper coaching or are not able to join a mock tests which are conducted by various institutes across India. These students need to get some source of knowledge by which they would also be able to crack the preliminary examination which are conducted in their state. So for the very same purpose, I have posted these videos. So I want you to share these videos to those students who are not able to afford for the same, and to your friends and relatives, juniors who are interested in preparing for these examinations as well. The questions are framed in English, and the explanations to each question are also in English. So there is no language barrier between us. So I want you to follow my channel, subscribe to it so that you don't miss the other 1000 parts of this particular session. Moving ahead to the first question. The Supreme Court of India has traced the right of privacy in Article 14, 19, 21, 22. So these articles are with respect to the Constitution of India. So the correct answer to this question is Article 29, where it states about life and personal liberty. In Justice Case Puttaswamy versus Union of India, which is a 2017 landmark decision, a 9-bench constitutional bench was formed where it stated that privacy is an intrinsic part to life and liberty, wherein it protects the autonomy of the individual, informational self-determination, and right to make personal choices. And it also warned that any intrusion into this right must satisfy the tests of legality, necessity, and proportionality. So this particular 9-bench decision also had given some tests wherein we can exempt situations where, based on the legality, necessity, and proportionality, right to privacy can be forgone. Moving ahead to the second question. The equal protection of laws in Article 14 has been taken from which constitution? British Constitution, American Constitution, Australian Constitution, none of the above. I'll give you 3 seconds for every question so that you can think over the answer, and I'll give you the answer. These 50,000 questions are framed in such a way that to make you study for these examinations. These are not kind of mock tests that you prepare during your examinations. These are questions which make you study. There are 90% chances that questions from these 50,000 can be asked directly in your exams. So the correct answer to the question is option B, American Constitution. So Article 14 of the Indian Constitution reads that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This article contains two distinct concepts, namely equality before law and equal protection of law, whereas the equality before law doctrine has been borrowed from the British Constitution based on the rule of law, which we usually call it as a Dacian concept, as DC was the propounder of rule of law, and equal protection of laws was a concept which was borrowed from the American Constitution. So these concepts were incorporated in a single provision, Article 14, wherein it talks about the state is obliged not to deny to any person equality before the law and equal protection of laws. Moving ahead to the third question. How many representatives of the Anglo-Indian community can be nominated to the state legislative assembly by the governor of the state? So this question, I would like to remind you that there were two members who were nominated in the Lok Sabha during the um start of the constitution enforcement, and one member of the Anglo-Indian community was to be nominated to the state legislative assembly by the governor. But this particular position was removed, and now we have no members who are nominated from the Anglo-Indian community. So this particular provision was previously incorporated as part of the constitution to adequately represent the Anglo-Indian community if they had not been represented. And this was removed by the 104th Constitutional Amendment of 2019, which came into effect on 25th January 2020. And it also abolished the provision of nomination of Anglo-Indian members to the Lok Sabha under Article 331 and the state legislative assemblies under Article 333 of the Constitution. So this is a very important provision that you need to remember, and there are chances that this question arises in your exams. Fourth question. Under which one of the following articles of our Constitution an accused person has been guaranteed the right to be informed of the nature and cause of the accusation? Article 22.1, Article 22.3, Article 21, and Article 22.4. The correct answer to this question is option A, Article 22, Clause 1. So what it states is that it provides specific protections for individuals who are arrested under ordinary laws. This particular provision is not with respect to the preventive detention, but with respect to ordinary laws. It also states that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner. So being informed appropriately is one point, and the second point is that legal practitioners consultation is a right which is included as part of Article 22 Clause 1 as his choice. Moving ahead to the fifth question. The National Judicial Appointments Commission NJAC 2014 Act came into force on. So the answer is on April 13, 2015. So it came into force, but later on the advocates, Supreme Court advocates on record versus Union of India, which was a 2015 case, the Supreme Court of India declared it as an unconstitutional and void, as it cited the basic structure of the Constitution. Judicial independence being part of the basic structure of the Constitution. Any law which amends the basic structure of the Constitution will be declared unconstitutional and void. Adhering to this particular basic structure, the NJAC Act of 2014 was declared null and void, and the collegium system, which was previously there in appointing the judges of the High Court and the Supreme Court, was again replaced. Moving ahead, sixth question. Part 4A of the Constitution dealing with fundamental duties was added to the Constitution by. So as we all know that there are various constitutional amendments which take place in India, and one among those amendments is the fundamental duty insertion into the Constitution of India. So the fundamental duties was amended and inserted under the 42nd Constitutional Amendment Act of 1976. So there were originally 10 fundamental duties for the citizens of India under Article 51A under Part 4A of the Constitution. Later on, the 86th Constitutional Amendment Act of 2002 added the 11th fundamental duty to provide education to children aged 6 to 14, adhering to the international guidelines in the UN. Moving ahead to the seventh question. The President may, under Article 56, Clause 1, Subclause B, be removed from his office by a process of impeachment on the ground of proved misbehavior, incapacity, violation of the constitution, all of the above. The correct answer to the question is violation of the constitution. Only under the violation of the constitution, the president can be removed by impeachment under Article 51, Clause 1, Clause B to the Indian Constitution. And the manner for impeachment of the President of India is provided under Article 61. Moving ahead. Article 15 of the Constitution prohibits discrimination between citizens on the basis of religion and caste only, religion, race and caste only, religion, caste and sex only, religion, race, caste, sex, place of birth, or any of them. So the correct answer is D. This is an easy question. So as we read through Article 15(1), it states that the state shall not discriminate any citizen against on the grounds only on religion, race, caste, sex, place of birth, or any of them. Moving ahead to the next question. In which one of the following cases has the Supreme Court declared Article 15, Clause 5 as constitutional? Indira Sahni versus Union of India, Ashok Kumar Thakur versus Union of India, State of Madras versus Champakam Durairajan, TMA Pai Foundation versus State of Karnataka. The correct answer to the question is option B, Ashok Kumar Thakur versus Union of India. Article 15, Clause 5 was inserted by the 93rd Constitutional Amendment Act 2005. It enables the state to make special provisions for the advancement of socially and educationally backward communities, the SCs and STs specifically. The educational institutions, including private institutions, whether unaided or aided, excluding the minority educational institutions covered under Article 31. These institutions should make special provisions. The state can make special provisions, excluding these institutions, for the economic and social development of SEBCs. SEBCs means socially and educationally backward classes, and scheduled castes and scheduled tribes. So Ashok Kumar Thakur is a landmark decision on this stance. The Central Educational Institutions Reservation in Admission Act 2006 was challenged, which provided 27% reservation for OBCs in centrally funded educational institutions. The Supreme Court upheld the constitutional validity of this particular act of 2006 in its judgment, and the reservation policy for the OBCs in educational institutions were subject to creamy layer exclusion and non-applicability to minority institutions. So this is a landmark judgment on OBCs. Moving ahead to the 10th question. Right to life under Article 21 of the Constitution does not include a right to die has been held by the Supreme Court in. So as we know that Article 21 deals about right to life and personal liberty. So does that mean that we can die? We have a right to die. And the Supreme Court stated that right to die is not included as part of Article 21, right to life. This particular judgment was upheld in Gyan Kaur versus State of Punjab. Option B is the correct answer. Moving ahead. A right to work in the Constitution can be traced in fundamental rights, directive principles of state policy, preamble of the Constitution, none of the above. So as we know that the directive principles of state policy is an obligation upon the state to manage the welfare of the citizens of India, their work, their social security, economic development. So right to work as part of the directive principles of state policy, the state ensures that within the limits of its economic capacity, that is, if the state's economic capacity is within India, and development make effective provisions for securing the right to work, to education, and to public assistance in cases of unemployment, old age, sickness, and disablement. So there is an obligation on the state that in cases wherein unemployment is at peak, the state shall provide, within the limits of its economic capacity and development, secure to its citizens a right to work. So right to work is a part of Article 41 of the Constitution of India under DPSP. Moving ahead, who amongst the following has said that Indian Constitution is a federation with strong centralizing tendency? So the correct answer to the question is option A, K.C. Vere. There is a misconception among many students that Sir Ivor Jennings has also said on federation with strong center, but he has not spoke about federation, wherein he has talked about the federal system is leaning towards the center. Okay, so the correct answer to this statement is K.C. Vere. Option A is the correct answer. Moving ahead, 13. For how many period, sorry, for how much period can the president appoint additional and acting judges in high courts under the Constitution of India? Not exceeding 2 years, not exceeding 3 years, not exceeding 1 year, not exceeding 5 years. The correct answer is not exceeding 2 years. Option A is the correct answer, and it is mentioned in Article 224, Clause 1 to the Constitution of India regarding additional judges. I want you to read the explanation part in detail so that you may get many questions from those points. And moving ahead to 14th question, Article 142 of the Constitution is supplementary in nature, gives preference to equity over law. Decisions under it do not constitute precedents under Article 141, all of the above. So to understand the question, we need to read through what Article 142 says. So Article 142 Clause 1 empowers the Supreme Court to pass such decree or make such order as it is necessary for doing complete justice in any cause or matter pending before it. This is an extraordinary constitutional power enabling the court to provide relief beyond the limits of ordinary laws when required to do complete justice. So now let's read the question. Article 142 of the Constitution is supplementary in nature. Yes, it is supplementary in nature. In case the ordinary laws do not stand by or provide complete justice, there is an extraordinary jurisdiction which empowers the Supreme Court to act immediately for the application of justice. So it is correct. The second one gives preference to equity over law. Yes, it gives preference to equity over law, but not absolutely. So absolute equity is not provided, but there is still preference under this provision. Decisions under it do not constitute precedents under Article 141 to the Constitution. They do not constitute precedents. Yes, they do not, because only there is a law which everyone has to adhere. Only in circumstances where the constitutional power needs to be enforced, then this decision is mandatory, and otherwise the law applies for particular instances. But to this question, Article 142 has all these powers, and it does not form a precedence under Article 141. So all of the above is right. The correct answer to the question is option D. Moving ahead, so I want you to read the explanation part to have a better clarity on what I said and what precedence these decisions were taken to this question. There are questions on 142 which are asked in mains as well. If you are able to write the explanation part alone in your mains examination, you will get full marks in your mains. Moving ahead, 15. Which one of the following is considered as the supreme source of power? Supreme Court of India, Parliament of India, President of India, Constitution of India. So who has the supreme power? Supremacy of Constitution, right? India follows supremacy of constitution. The constitution of India is the supreme law of the land. Neither the president nor the parliament or the Supreme Court is supreme. The constitution of India is supreme, and the Supreme Court has an obligation to uphold the constitution of India and its mandates. This particular principle of basic structure was propounded in Keshavananda Bharati versus State of Kerala, 1973, which is a landmark decision on the constitution, wherein it stated that preamble is part of the constitution of India. Moving ahead, which one of the following does not apply to the term of office of governor? The governor shall hold the office during the pleasure of the president. Minimum age for the post of the governor shall be 32 years. The governor may resign by handwritten sign addressed to the president. The term of governor shall be 5 years, which does not apply to the term of office of the governor. Option B is wrong, actually, so it does not apply. The minimum age for the post of the governor shall be 32 years is wrong. Moving ahead to the next question, the age is 35 actually. It shall be the duty of every citizen of India who is a parent or guardian to provide opportunities for education to his children, or, as the case may be, ward between the age of 6 to 14 years. By which Constitutional Amendment Act was this duty included? As we all know that in the previous question, in this particular session, we saw that Part 4A to the Constitution was included as a fundamental duty by the 42nd Constitutional Amendment. But later on, the 11th provision to the fundamental duties was inserted by the 86th Amendment Act. And the provision states that children between the age of 6 to 14 years should not be, they are to be provided with education and opportunities for education by the parents and guardian. So 86th Amendment is the correct answer. Option C is the correct answer. Moving ahead. Which one of the following is not a way of termination of citizenship? So citizenship can be terminated by multiple ways. There are certain ways wherein the Constitution also mentions how citizenship can be terminated, and then there are additional instances where the Citizenship Act also mentions how a citizenship can be terminated. So one such way, which is not the way of termination of citizenship, is C. Option C is the correct answer. The tour journey of another state for few months. So in case you go for a tour journey to another country, so on those grounds, termination of citizenship is not provided, right? So abruptly we know that this is a statement which is not looking to be an answer. So that is the correct answer. Moving ahead. 19th question. In which of the following cases did the 5 judges constitutional bench observe that the doctrine of postponement was aimed at balancing the right of an accused to be presumed innocent till completion of trial with the media's right to freedom of expression? So the doctrine of postponement was propounded in Ajay Kumar Parmar versus State of Rajasthan. So the correct answer to the question is option A, Ajay Kumar Parmar versus State of Rajasthan. So I want you to pause for a while and read the question. While deciding cases of terrorists, which procedure is to be followed? Procedure established by law, procedure established by the Constitution, both A and B, none of the above. So the correct answer is option C, both A and B. Article 21 states that the Constitution guarantees that no person shall be deprived of life or personal liberty except according to the procedure established by law. But the Supreme Court has later on interpreted through various precedents that the procedure established by law was to mean that The procedure should be fair, just, and reasonable procedure, which consists of principles of natural justice and the Constitution. So, when trying terrorists, the statutory laws governing the investigation and the prosecution of terrorism related offences, example, the UAPA or the Terrorist Disruptive Activities Act, which includes the constitutional safeguards such as the right to fair trial, right to counsel, right against self-incrimination, needs to be provided. Hence, the statutory procedure law and the constitutional provisions must go hand in hand, and it must adhere to ensure the justice and protection of the rights of individuals who involve in these terrorist activities. Moving ahead to 21. In which of the following decisions did the Supreme Court observe that mercy petitions filed under Article 72 and 161 should be disposed of within a period of 3 months from the date when it is received, as unwanted delays tend to shake the confidence in the system of justice? So, as we read the question, we understand what it means. So, mercy petitions are filed by individuals who are put death sentence by doing heinous crimes, and within a period of 3 months from the date of its receipt of these petitions, decisions should have to be given, and the matter should be disposed of. So, mercy petitions go to the President of India. So, this was held in option B, Maru Ram versus Union of India. Option B is the correct answer. So, Article 72 deals with wherein the President has power to pardon in mercy petitions, and Article 161, the Governor is empowered to pardon for mercy petitions. 22. In which of the following decisions of the Supreme Court of India did a 7 judges bench explain the concept of public interest litigation? So, a 7 judge constitutional bench was formed to explain the concept where a litigation was filed with regard to bill. So, the case was SP Gupta versus Union of India. So, this is a landmark judgment on public interest litigation. Moving ahead, 23. The person associated with public interest litigation is Justice Bhagavati, Justice R.N. Mishra, Justice Mingida Chellaya, none of them. The correct answer is Justice Bhagavati. Option A is the correct answer. So I want you to pause for a while and read about the public interest litigation part of Justice P.N. Bhagavati's and how he explained the concept. Moving ahead, 24. In which of the following cases did the Supreme Court call Article 22 of the Constitution an ugly provision of the Constitution? So, in one of these cases, the Supreme Court has called Article 22 itself an ugly provision to the Constitution. So, the answer is D. Option D, A.K. Gopalan versus State of Madras. So, why did it call it as an ugly provision to the Constitution? Is it because it allowed preventive detention, which restricted the personal liberty without the usual safeguards available in the ordinary criminal laws? Moving ahead, we are in the mid of the session. 25. Which one of the following is not included in Article 21 of the Constitution of India? We have already discussed this. The answer is option A, right to die. Gyan Kaur versus State of Punjab, as we already saw. 26. In which provision of the Constitution of India is incorporated the principle of collective responsibility of the Council of Ministers? Council of Ministers, along with the Prime Minister, they have a collective responsibility. So this is mentioned in Article 75, Clause 3. 27. Which one of the following statements is not correct? No mandamus can be issued to enforce an act which has been passed by the legislature. Court cannot issue any direction to the legislature to make any particular kind of enactment. Supreme Court may give a direction for amending an act. Under the constitutional scheme, Parliament and the state legislatures exercise sovereign powers to enact law. So the wrong statement here is the Supreme Court may give direction for amending an act. The Supreme Court has no powers to give directions to amend an act. It is on the legislative assembly to pass motions and enact a law, and the Supreme Court can only direct the legislature, um, like the Supreme Court can only declare a law which was already passed by the legislature unconstitutional or strike them down, but it does not have a power to instruct the legislature to amend any laws already there or the legislature is discussing about, because the legislature is a sovereign lawmaking body with its own constitutional limits. 28. The binding force behind the directive principles of state policy is public opinion, government, constitution, administration. Public opinion. Option A is the correct answer. Propagation means, sorry, I misspelled it. Prorogation means prorogation. So prorogation is basically the termination of a session by the president. Moving ahead, mention the chronology of the following judgments of the Supreme Court of India, starting from the earliest up to the latest case. So you have to basically know in which year which case was decided to answer the question. So the correct answer is Mr. Balaji versus State of Mysore was the first case, and the second case is Akhil Bharatiya Shoshit Karmchari Sangh versus Union of India. The third one was Indra Sani versus Union of India, and the last one was AIMS Students Union versus AIMS. Moving ahead. 31. Discrimination by law in the marriageable age of boy 21 years and girl 18 years. So does it offend the Article 14 of the Constitution, which is equality principle, or it does not offend Article 14, or is it against the rule of law, or it violates humanity? So the answer is it offends Article 14 of the Constitution. Then you might ask a question, why was it there in the Constitution? There are many instances wherein the Constitution had provisions which were unconstitutional without understanding or interpreting the basic structure of the Constitution. But at later point of time, we understood through many precedents that what it means, and the legislature is taking efforts to legislate these laws and to ensure that equality prevails without any gender stereotypes or bias. Moving ahead. 32. Point out the incorrect response. Ownership is classified in the following ways: corporeal and incorporeal ownership, mediate and immediate ownership, sole and co-ownership, vested and contingent ownership. The correct answer is vested and contingent ownership. Option B is the correct answer. So vested and contingent ownership is an incorrect response. Which one of the following is not a safeguard against delegated legislation? Parliamentary control, judicial control, publication, public control. So in delegated, under the concept of delegated legislation means you delegate some other person to legislate a law instead of the empowered party. Okay. So the legislature is empowered to legislate, wherein it delegated certain part of legislation to some other authority. So which one of the following is not a safeguard against delegated legislation is the question. So the answer to the question is public control. Public control is not a safeguard, whereas parliamentary control, judicial control, publications are safeguards against delegated legislation. Next one. Give the correct response. The obiter dictum has binding force. Ratio decidendi has binding force. Ratio decidendi and obiter dictum both have binding force. Neither ratio decidendi nor obiter dictum has binding force. So these two words are Latin maxims. So obiter dictum is concepts and the judge's personal opinion that he declares when pronouncing a judgment. So it may relate to the judgment or it may not relate to the judgment, but it might have links to the judgment. But it is basically not the reason for which the decision was taken. So reasons for which the decision was taken is dealt in ratio decidendi. So through this explanation of mine, you can understand that obiter dictum can be anything which the judge opines, and ratio decidendi has a binding force of the judgment as it relates to the judgment itself. So option B is the correct answer. Which one of the following is not an element of a legal right? Option A, the subject, that is holder of right, the object of right, the act or forbearance, legal remedy. So it is not an element of legal right. So the subject, that is the holder of the right, has a legal right. The holder of the right has a right. So it is legal. So it is an element. So the object of the right. So the holder of the right will have an object for the right. So it is legal. The act or forbearance. So the person who has a right can act in a certain way or to forbear or omit from doing a particular act. So he might have a legal right on it as well. But a legal remedy is not an element of a legal right. So it is a decision which is taken later on based upon the act or omission. Which one of the following is not a legal person? Idol of goddess Durga, state of Kerala, a registered society, mosque. If they had given it as some temple with its name, then it is a legal person. But an idol of goddess Durga or the idol of Shiva is not a legal person. Which one of the following cases is related to possession? You can choose one or multiple options from these questions. So this question is to make you to study or to know what are the cases wherein possession has been declared as an important part in the judgment, and these are landmark judgments too. I don't want to miss any particular case. That is the reason I have incorporated all those cases wherein it relates to possession, and I have made it. You can select multiple options. Is it all the four or any one or two? You can choose whatever. So the answer is A, B, and C. R.V. Chisers, Mary versus Green, R.V. Hudson. Galilei versus Lee and others is not part of possession. So I want you to pause this and read 38. A handed over his watch to a watchsmith for repairing. In order not to pay the repairing charges, A picked up his watch from the shop. When the watchsmith was not looking, in this case, A is guilty of criminal breach of trust. A is guilty of cheating. A is guilty of theft. A is not guilty of any offense because the watch he picked up was his own. However, he should pay the repairing charges to the watchsmith. The correct answer to the question is A is guilty of theft. Only he repays or pays the amount for the repairing charges, then he has a substantial interest in the watch. Otherwise, it amounts to theft. 39 on your screen. In which one of the following offenses mens rea is not an essential element? So the guilty mind is not a part as an element in assault, bigamy, defamation, none of the above. The correct answer to the question is bigamy. So bigamy is having two spouses simultaneously. So this is considered a strict liability offense. It does not come under the jurisdiction of section 494. So bigamy is under 494 of IPC and it does not have mens rea. Guilty mind is not there. 40th question. Which one of the following pairs is correctly matched? Counterfeit section 28, valuable security section 29, document section 30, omission section 31. The correct answer is counterfeit section, which is in section 28. Next question. Punishment provided for kidnapping for ransom under the Indian Penal Code is up to 7 years imprisonment, life imprisonment only, death sentence or life imprisonment, 10 years rigorous imprisonment. So kidnapping for some ransom, you need to serve a punishment of death sentence or life imprisonment. So option C is the correct answer. 42. The time barred debt is a we already saw this question in our previous part. I have repeated because it is a very important question. Imperfect right. Time barred debt is a imperfect right. Option B is the correct answer. Which one of the following statements is correct? In conspiracy, there is no distinction between principal and accessory. In conspiracy, principal and accessory are distinct. There has to be a distinction between principal and accessory in all offenses. None of the above is correct. So B and C are wrong. In conspiracy, there is no distinction between principal and accessory. So option A is the correct answer. 44. Match list 1 with list 2. So as we read through these questions, I'll answer. Rex versus Levitt belongs to insanity. So Rex is an insane person, whereas the case was filed on his behalf by his relatives. Tabu Chetia versus State of Assam. Rex versus Levitt is related to actually murder, and Tabu Chetia versus State of Assam was related to insanity. Tabu Chetia was the person who was insane. Vijayan versus State of Kerala, mistake of law, mistake of fact. State of UP versus Birendra Prasad is related to criminal conspiracy. So I have given you the correct options in this particular box. Pause it for a while and read it. A meets a girl aged 15 in a park. She tells him that she is 16 and is ill-treated at home and would be happy to be taken away. A then takes her to his house and allows her to stay there. In this case, did A commit no offense as the girl has come with him with her own consent, or A has committed no offense as the girl misrepresented her age and A believed her matured and capable of consenting, or A has committed the offense of kidnapping of minor from the lawful guardian, or A has committed the offense of kidnapping and wrongful confinement. So in this situation, A took her away without the consent of her lawful guardian, her father. So therefore, the act amounts to kidnapping from lawful guardianship, and A's belief of her consent is irrelevant in the eyes of law. Moving ahead to the 46th question, the phrase "in furtherance of common intention of all" used in section 34 of the Indian Penal Code is in the original draft added by Amendment Act of 1870, not at all there, added by Amending Act of 1986. So we all know that section 34 is with respect to the common intention in committing any crime, and section 149 of the Indian Penal Code, it deals with wherein you form an association and you commit some crime, then you are being penalized on it. So this particular provision was added by the Amendment Act of 1870 into the Indian Penal Code of 1860. So in 10 years time, it was added. Moving ahead to the 47th question. Use of violence by a member of an assembly of 5 or more persons in furtherance of a common object will constitute the offense of. So more than 5 people join together with a common object under section 34 of IPC, and you commit an offense. Rioting. So this particular violence also involves section 149. Unlawfully assembling together with a common object to commit a crime. 48. Match list 1 with list 2. Delivery of property, criminal breach of trust, taking of property, criminal misappropriation, entrustment of property, theft, convertibility of property innocently got to own use. So I have given you the answer in the next slide. So delivery of property is extortion, taking up of property is theft, entrustment of property is criminal breach of trust, convertibility of innocently obtained property is criminal misappropriation. So in cases wherein list 1 is specified and you commit an offense with respect to the list 1, so that offense is mentioned in list. Next question. A picked up a matchbox belonging to B and lighted his cigarette with it. B charged A with the offense of theft of his matchbox. In these circumstances, A can defend himself with the help of which one of the following legal maxims? Non compos mentis, doli incapax, de minimis non curat lex, ignorantia juris non excusat. So elimination will work out here. Doli incapax means a person who is a minor. They have not mentioned anything about minor in the question, so straight away we remove it. Ignorantia juris non excusat. So ignorance of justice is not excusable. So knowing law and not knowing law is not a part of the question, and we remove it. Non compos mentis. So the correct answer is option C, de minimis, non curat lex. The law does not concern itself with trifles. And the last question of this part, which is an assertion to reason. Homicide is the killing of a human being by another human being. Reason, homicide is always unlawful. So the reason is appropriate and is the correct explanation, or both are true and reason is not the correct explanation for the assertion, or the assertion is true but the reason is false. or the assertion is false but the reason is true? The correct answer to the question is assertion is true. Yes, homicide is killing of a human being by another human being. Yes, it is right. But homicide is always unlawful is not a possible reason for the assertion. So reason is false. Because at times you kill someone due to private defense, or the court may execute some person through an order and the hangman hangs you. So in such situations, it is the procedure established by law which makes the act lawful, and it is not always unlawful. So the reason to the assertion is not true and the assertion is true here. And last and final, your homework question, point out the wrong statement. Intentionally destruction of Intentionally destructing of property for causing wrongful loss to any person is mischief. Intentionally putting any person in fear of injury and thereby dishonestly inducing him to deliver any property is extortion. Five or more persons conjointly committing robbery amounts to dacoity. Two or more persons quarreling anywhere commit affray. So which among one of these is a wrong statement? I want to choose that. So mention the answer in the comment section. So with this, I end part 9 of our 50,000 multiple choice question series. A great thumbs up to each and every student who watched the complete section till the end. And I want you all to share the video as much as possible to your friends, relatives, and students who prepare for these exams, and people who are not able to afford for going to any coaching or attending mock tests. With that, I sign off. See you in the next interactive session, part 10.